Pauline Hanson recently lost her case in the federal court against Mehreen Faruqi. The case was brought under Section 18C of the Racial Discrimination Act. So let's talk about that a little bit here and see why exactly the case was brought and whether Pauline Hanson has a case and a chance on appeal. And if you've got any thoughts about it, well, let me know that in the comments below. So let's start with what the case actually relates to. Well, it relates to Pauline Hanson telling Mehreen Faruqi to pay off back to Pakistan. And she also said that Mehreen Faruqi had taken advantage of Australia. This came by way of a tweet. The full tweet stating, "Your attitude appalls and disgusts me. When you immigrated to Australia, you took every advantage of this country. You took citizenship, bought multiple homes, and a job in Parliament. It's clear you're not happy. So pack your bags and pee off back to Pakistan." Now, there was some context to this, much like there is to all of these things. Indeed, Pauline Hanson's tweet was in fact a response to Mehreen Faruqi's prior tweet. Mehreen Faruqi's initial tweet stated, "Condolences to those who knew the Queen. I cannot mourn the leader of a racist empire built on stolen lives, land, and wealth of colonized people. We are reminded of the urgency of treaty with First Nations, justice and reparations for British colonies, and becoming a republic." So Pauline Hanson was seemingly responding to Mehreen Faruqi's rather tasteless tweet about the Queen after the Queen had passed away, and her sentiments about the nature of the British Empire as it was then, and the UK as it is now. Mehreen Faruqi, who is a Green senator, then brought the case under Section 18C of the Racial Discrimination Act. So let's have a look at what Section 18C says, because that's obviously what the case is going to turn on, at least primarily. Section 18C states that it is unlawful for a person to do an act, otherwise than in private, if A. the act is reasonably likely in all the circumstances to offend, insult, humiliate, or intimidate the other person or a group of people, and the act is done because of the race, colour, or national or ethnic origin of the other person, or of some or all of the people in the group. The section also states that for the purposes of this, the act is taken to not be done in private if A. it causes words, sounds, or images or writing to be communicated to the public, or it is done in a public space, or it is done in the sight or hearing of people who are in a public place. So let's have a think about this. Mehreen Faruqi was told to, quote, pee off back to Pakistan. Now the question is then whether that was done because of the race, colour, or national ethnic origin of Mehreen Faruqi, or done for some other reason. Now certainly, for the purposes of this section, if it is done for mixed reasons, it might still violate the section. So for example, say hypothetically Pauline Hanson told Mehreen Faruqi to pee off back to Pakistan, and it was partly because Mehreen Faruqi was from Pakistan, and partly because of other reasons, it can still hypothetically run afoul of Section 18C. It would really have to depend on what the dominant purpose of the statement was. So with this in mind, and rather unsurprisingly, Pauline Hanson argued that her comments were not driven by Mehreen Faruqi's race or her religion or anything else. She argued several things, and this is extracted in the court's judgment. She said that she was disgusted by Senator Faruqi viciously insulting the Queen on the day of her death. She stated that she was disgusted with Senator Faruqi's hypocrisy, being in relation to her oath of allegiance to the Queen and having, quote, benefited enormously from a country she was now criticising. She was disgusted by the insincerity of Senator Faruqi's expression of condolence. She wanted to stand up for the values of her constituents. She wanted to stand up for an institution that Senator Faruqi had decided to attack, presumably here the British Empire or the United Kingdom. And there was nothing about Senator Faruqi's race, colour, or origin that means she should not be in Australia. It was her attitude that was the problem. Her attitude toward Australia and Australians. But the judge disagreed with Pauline Hanson's assertions, and the judge stated, and I'm quoting here from the judgment, "I've already said that I have considerable doubt about whether Senator Hanson gave the wording of her tweet the thought that she said she did in her affidavit. I find that the affidavit was an ex post facto attempt to justify and explain the tweet. Time and again, she said in oral evidence that she dictated the tweet in distress, disgust, and anger, and that she did not check the wording of the draft. She did not take the time to reflect on her chosen wording. I find that she framed the tweet spontaneously and in the heat of the moment. In any event, except for the last one, none of the reason that she gives excludes a factor or a reason for the tweet being one of the paragraph B factors. That is, Senator Faruqi's race, origin, etc., etc. Even if Senator Hanson subjectively thought that Senator Faruqi had viciously insulted the Queen, or that what she said was insincere and hypocritical, that does not explain why her response was framed as anti-immigrant, racist, and anti-Muslim, or exclude those as being the reason for the tweet being framed in that way. Insofar as the last of Senator Hanson's reasons is concerned, it is framed as a denial and is sought to be justified on the basis that Senator Faruqi showed some sort of reprehensible attitude to Australians or Australia. But even as Senator Hanson's tweet was thus primarily actuated by criticism of Senator Faruqi's attitude to Australia or Australians, that does not explain its racist, nativist, and anti-Muslim content, other than being, quote, because of the race, colour, national or ethnic origin of Senator Faruqi. In the circumstances, I am left with the messages themselves in their context. There is no satisfactory explanation for them other than what their content and context evidences, which is that they were conveyed because of the colour, national origin, and Muslim identity of Senator Faruqi. Prima facie, a racist and nativist attack is made, quote, because of the race, colour, or ethnic or national origin of the person targeted. In the absence of any compelling or sufficient evidence to the contrary, I conclude that a cause of Senator Hanson having posted it in those terms was the race, colour, or national ethnic origin of Senator Faruqi. So let's evaluate this, because I'm not sure that I agree with the judge here. I personally actually think that Senator Hanson's characterization of the tweet makes a lot of sense, because if we look at it in context, Mehreen Faruqi's initial tweet was about the Queen and about the Queen's death. It makes sense in that context for someone to be appalled by the sentiments Mehreen Faruqi expressed. After all, it was incredibly tasteless to express that in the way she did. The Queen had just died, the Queen is a human, and any individual human dying is a tragedy. So Mehreen Faruqi's comments were at the bare minimum tasteless and a little bit vulgar. It makes sense that Senator Hanson would react slightly vitriolically. Indeed, many Australians did react rather negatively. Now, in characterizing Pauline Hanson's tweets as racist or offensive in that nature, the judge also had regard to Pauline Hanson's other, broadly anti-Islam types of comments. For example, her comments about Islam in general, her comments in general about immigration. And in that context of Pauline Hanson's background, the judge decided to characterize Pauline Hanson's tweet as being racially driven. However, I think that's a little bit of a misdirection, because someone can have racially driven comments in another context, but we have to look at this specific tweet. And this specific tweet, Pauline Hanson was commenting on Mehreen Faruqi's attitude toward the Queen, and was commenting about Mehreen Faruqi's attitude toward the Queen in the nature of Australia existing. So Pauline Hanson was trying to convey the idea that Mehreen Faruqi had moved to Australia, and as is her right, she had developed wealth and developed a reasonably strong position as a senator within Parliament, and therefore she had gained advantages by being in Australia. Now, I don't think that is necessarily up for debate. She clearly gained from being in Australia, and that's a good thing. People should be able to gain from being in Australia. It's a good thing for people to be aspirational and to succeed. Pauline Hanson, however, was expressing that she had succeeded in Australia. She had bought several properties. She had earned a high income as a senator. She had reached almost the pinnacle of public life, being in Parliament. And now she was attempting to tear down the institutions that had built up that Parliament, being, for example, the Queen and the British. After all, Parliament would not exist but for the UK. To my mind, Pauline Hanson was expressing the idea that if she didn't particularly like the institutions that had been built here, and she didn't particularly like the economic and social context that had been built here, then she should ultimately leave. Now, in my opinion, this was not necessarily driven by Mehreen Faruqi's race. Rather, it was driven by her sentiments. And this tweet could very well have applied to myriad other people. Now, it happened to apply to someone who is Pakistani and Muslim in this context. However, one could also apply this tweet to many other people. Now, to be clear, Pauline Hanson did seemingly not send such a tweet or response to other people, but nevertheless, it could easily apply. So say, for example, we think about a situation. Say a Sydney-sider is annoyed by a Melburnian's economic policies because Melbourne is buried under debt and is a trash fire. And then that Sydney-sider tells the Melburnian to go back to Melbourne when they try to bring their bad policies with them. In this case, that sentiment would be motivated by the person's bad policies and the decision to make Sydney a trash fire like Melbourne. So, applying that same logic to this situation, Pauline Hanson would be arguing, well, the situation in Australia is good to Pauline Hanson's mind, and therefore, if someone wants to change a good situation, they should go away. In this case, in the case of Mehreen Faruqi, that would involve going back to Pakistan. I therefore would personally argue that Pauline Hanson's tweet was not motivated by the race or ethnicity, etc., of Mehreen Faruqi. But of course, the judge in this context disagreed with me. Now, there are probably a few reasons for that disagreement. First, there's just a general different interpretation of the fact scenario. Second, the judge had regard to Pauline Hanson's background and inferred that because Pauline Hanson had made other anti-Islam remarks, she therefore was always going to be motivated by those when making tweets of this nature. Third, the judge looked at the nature of the tweet and argued that if you're telling someone to, quote, go back to Pakistan, then that would be inherently a racist comment. To my mind, I can see some logic in the judge's thoughts here. However, I would argue that in this specific tweet, one could substitute go back to Pakistan with leave Australia and apply it to anyone, whether or not that person had come here from overseas or whether they'd been born in Australia. Therefore, I think that go back to Pakistan part of it was simply a way of phrasing leave Australia, and therefore the tweet was not motivated by the race or ethnic origin of Mehreen Faruqi, but rather was motivated by her sentiments and Pauline Hanson's desire for her to go away in general. Although I will note that it would be incredibly dangerous, it seems, to tell someone to, quote, go back to Pakistan in the light of the court's judgment, and one would be ill-advised to do so. I can certainly think of many senators in addition to Mehreen Faruqi that would be taking advantage of Australia, who is sitting in the Senate and sitting back and making things worse. An example of this would be Lydia Thorpe, who I think is taking advantage of Australia because of her position in the Senate and advocating for bad policies, but not because she happens to be of Indigenous background. Here, it is the policy aspect of it. For example, there are other senators and members of the House that are Indigenous and not taking advantage of Australia. There would be, for example, Jacinta Nampijinpa-Price or Linda Burney. They've been acting in their constituents' interests. Now, I might disagree with Linda Burney's policies, but she is clearly not taking advantage of Australia. Similarly, there are other Muslim politicians that are not taking advantage of Australia. An example would be Ed Husic in the ALP. He is clearly not taking advantage of Australia. And many Pakistani people are not taking advantage of Australia. To my mind, Pauline Hanson's statements pertain to Mehreen Faruqi taking advantage of Australia by sitting in the Senate and then advocating for the Greens policies that make things worse. Now, under Section 18D, there are also some exemptions to Section 18C. The exemptions include, for example, if the comments were made in the performance, exhibition, or distribution of an artistic work. That would not apply to Pauline Hanson comments. Under subsection B, it says, if the comments were made in the course of any statement, publication, discussion, or debate made or held for genuine academic, artistic, or scientific purposes, or for any other genuine purpose in the public interest. Now, Pauline Hanson might try to argue this. She might try to argue that, and indeed this is coming up at the federal court, that her comments were made in the genuine public interest because she was trying to advocate in a policy position. A lesson for everyone is never to just tell someone to go back to where they came from, so to speak. Rather, you should make sure you add the full context of what the problem is, so it is abundantly clear that it is not because of the person's racial or ethnic background. Under subsection C, it's also an exemption if the comments were made in the making or publishing of a fair and accurate report of any event or matter in the public interest. I'd say that probably would not apply here because this was not really a report Pauline Hanson was doing. And or under subsection 2, a fair comment on any event or matter of public interest if the comment is an expression of a genuine belief held by the person making the comment. So here Pauline Hanson could argue she was making a fair comment, and fair comment would be a little bit tricky here, but still she could be making a comment that Mehreen Faruqi was taking advantage of Australia. I think for that to really leap above the bar of being a fair comment, as opposed to just a comment, she would need to describe why Mehreen Faruqi was doing so in the comments specifically. Not just that she was taking advantage of Australia, or she should pee off back to Pakistan. However, this is clearly a genuine belief held by Pauline Hanson. So we wrap all of this up. What do I think about Pauline Hanson's position here? I think she shouldn't have lost the case. I think she shouldn't have lost the case because I don't believe these comments were made because of Mehreen Faruqi's racial or ethnic background. I think the comments were made because of Mehreen Faruqi's policies. I would argue that Pauline Hanson would believe similarly about all Greens politicians, regardless of their racial or ethnic background, and therefore it would not fall within Section 18C. But do let me know your thoughts about this in the comments below. Do you think Pauline Hanson deserved to lose, or do you think perhaps she has a case? Let me know your thoughts.